Avoid Explained, a project of Greater Chicago Legal Clinic. My name's Adam Salzman. I'm the Executive Director of Greater Chicago Legal Clinic. And I am very pleased to be joined today by Marta C. Bukata, one of our longest serving attorney at the clinic.
I think so.
Yeah.
I think so.
And certainly one of our most accomplished and the most dedicated. So thank you for taking some time to be with us today.
Thank you for inviting me. I really enjoyed this.
I'm glad to have the opportunity to talk to you. So I thought for our discussion today, we would just dive right in and talk about your practice. And specifically, I wanted to talk about family law because that's a large part of what we do at GCLC. And it's one of the things I think that really distinguishes us from other organizations. It can be very, very difficult if you have limited resources to find quality family law representation in the legal aid space. But that is one thing that the clinic has, I think, always done. Am I correct about that?
Correct. And this is the advantage and the uniqueness, I think, of the legal clinic, which is to provide legal services to the poor and working poor. That is to say, the working poor is the one that is most challenged to get legal services. Why? Because the poor will qualify, since they don't have any income or they have below a certain federal guidelines of poverty, they can get representation by many of the other legal service providers. However, if you are the working poor, that is to say you are getting a salary, you are getting an income, but you don't make enough to actually have a private attorney to represent you, then the clinic will provide you services according to your income anywhere, and they will charge you anywhere between $50 an hour to $80 or $90 an hour. Because if you can afford more than that, you can certainly go to a private attorney. Now, we don't want to be in competition with a private bar. Consequently, that's the uniqueness of the clinic.
I think that's a really, really important point, and one that we haven't yet focused on this television program that we're doing, which is that, there is a large, almost middle category of people who work, who are not wealthy, may be lower to middle class, or what you mentioned or characterized as working poor. So that's anywhere up to 400% of the federal poverty level, I believe.
I think that even a little bit below that.
Yeah,
but that's
399. But that is a very difficult place to be when you're looking for legal services, because typically, if you're looking at a private firm, how much can you expect to pay per hour?
Well, if it is a family law issue, which is what I do, they can charge you anywhere from $400 an hour to, the least probably would be $300. Yeah. But who can afford that?
Right. That's very, very difficult.
And then you have the working poor that finds itself, the working poor, served with papers, for example, for a divorce. So is put in in a position in a legal system that he or she didn't look for. It is the result of the social issues. It is a result of the family having problems. And so I always wanted to practice the sociological, as I call it, the sociological application of the law. That is to say, to help families navigate the legal system. And if you are thinking, and that's my area of practice, is basically family law, domestic relations, but I also practice in adoption law, which, by the way, is not domestic relations, but
Right.
it's the county division.
Right.
But for some reason, the court system has divided that. But adoption is also, if you want to adopt a child or whatever, if you have a private attorney, that they can charge you quite a bit.
Right, right. So I think you gave us actually a very good place to start, which is let us imagine, here's a hypothetical. You are someone who I guess we'll categorize as working poor.
Okay.
And you are served with a petition for dissolution of marriage.
Yes, because it is not called divorce anymore.
Right,
It's
right.
called dissolution.
Dissolution, right. So if I come to the clinic
You
for
will
an
call
initial...
the clinic. Okay, let me give you a...
walk us through it.
Yeah. So that person, let's say, is the woman who gets served by her husband with the petition for dissolution of marriage, petition for divorce, and that person, that woman is going to come. Let's call her Mary. Mary will call legal service providers first of all to see, because she's a working poor. She's working poor. Or she might not even be working, so that she would call all the other legal service providers, and they probably don't have room, or they can't take the case, etc., etc. So they would call us. They call the clinic. They will do an intake, and one of the things that we say at intake is, we are going to schedule an initial consultation in which we are going to legally assess the merit of the case, to take it or not to take it. If she was served, then we are on an emergency, because if you are served, you have only 30 days to go ahead.
Clock is ticking.
The clock is ticking.
Yeah.
So we would try to make an appointment, an initial interview, as soon as possible. And then the difference is, before pandemic and now at pandemic time, we used to do the initial consultations in person. Now when the pandemic hit, and then we will do the initial consultations by phone. And now that the pandemic has kind of subsided, we give the person the opportunity. Do you want to do the initial interview by phone, or would you like to do it in person? I must say that for domestic relations cases, per se, we do charge $50 for that initial consultation. So we think now it's only fair that if the person wants to do it in person, then we should make ourselves available for that. However, the working poor has a schedule, and this is a reality that I just concluded. The working person has a schedule of usually 9 to 5, or is working, or has children that has to pick up from school, etc., etc. So what I have found is many of the initial consultations, if I tell them, if you want to have it in person, it will have to be the regular 9 to 5. If not, we can call you at any time. So I have had initial interviews at 8 p.m.
Right.
At 8 p.m. at night, which is fantastic, because by then they are relaxed, they are not in a hurry. Pre-pandemic, we would have an initial interview during their lunch break.
Yeah.
And then you had to hurry.
Right.
So this is one of the blessings
Right.
of the pandemic.
A blessing for both the attorney who can conduct an initial consultation with a client who's maybe a little bit more forthcoming and not as rushed, and also for the client, because they don't have to take off work. You might not get paid if you're not at work, first of all.
Many times.
Most frequently, right?
Right.
So while the pandemic was a difficult experience for all of us, in some ways it's created additional conveniences
for clients, for especially the working poor. So then we make the initial consultation, And then that is a comprehensive initial consultation. Why? It can take anywhere from 45 minutes to an hour. We don't rush. Not that I am going to criticize the other legal service providers or even private practitioners, but usually those other groups do not afford the initial consultation the significance and the importance that it needs. Why? As an attorney, I can determine, I can assess the legal consequences of that case. You were served, you have 30 days to file your appearance. By the way, without even taking that case, that is to say, without necessarily being retained by that person, we will many times prepare the appearance and the answer to the petition so that at least
they don't blow the time frame.
The time frame,
Right.
exactly.
Right.
So that's one type of services that the private bar will not.
Well, I think you raise a very important point also, because this touches on the clinic's mission, which is somebody may come in for an initial consultation, and they may choose not to retain us as their attorney. But that doesn't mean that we're not providing them a service, because part of our mission is education.
Right.
And simply by having the consultation and explaining to them how the process works, the clinic is providing a service.
Absolutely, absolutely. And so, and especially because that consultation is with an attorney. It's not with a paralegal who cannot make cannot give a legal advice.
Right.
I mean, we'll have to take down all the information passively, and then we'll say, I will have to consult with the attorney, and then we will tell you if we're going to give you a retainer or whatever. So I really like that aspect of the clinic.
Yeah. And I think that's something that both you and also the people who have, because you have experience as a teacher, and I think that as a mentor to younger attorneys, they have learned from you, and I think that thoroughness that you bring to the initial consultation is something that has filtered down through the entire organization, and it's something that makes us unique.
Yes.
Yeah.
Well, okay.
Yeah. So you've taken us or talked a little bit about the initial consultation. So let's move a little further in our hypothetical, and let's assume that we are retained.
Right. In that initial consultation, we do tell the person very clearly and several times, the fact that you pay the $50 for this initial consultation doesn't obligate you to retain us. So if you want to go to another attorney or you want to do it on your own, because sometimes these people are sophisticated enough that they can do it on their own.
Right. Pro se.
Pro se, right. By the same token, the $50 that you pay us doesn't obligate us to accept your case. There might be some reasons why we won't take your case. Why? For example, we might need additional information, additional documentation in order to assess whether we can take the case, even if you want us to take it. However, it is important to know that usually that second interview that the person will provide you, and now this is another advantage, they can provide you with documents electronically. They don't have to bring them to the office in person and make a copy.
That's a really positive change.
Absolutely.
Yeah.
So we won't charge $50 for the second consultation because it's the continuation of the hour of from the first one that we are going to go ahead. So let's assume then that the person wants us to represent them.
Mary. Marry the client.
Mary, the client, wants us to represent her. And so we will provide a retainer contract. The retainer contract, the ones that at least I prepare, are very detailed, exactly on what we are going to do and how many hours are devoted, etc., etc. In the meantime, we are charging, let's say that we charge Mary $50 an hour.
And we decide that rate based on her income.
Correct.
Right. So
Correct.
when we charge money, it's always income sensitive.
Correct.
Right.
Except that for family law cases, we decided, the policy of the clinic for many years has been, we will charge something. Even if the person doesn't have the money, or let's say Mary is a housewife that has 3 children and is not working and doesn't have the money, we will charge her something. And they come up, believe me, they come up with the money, especially in an emergency. So we will charge them, and we will keep track of our time. However, the reality is, and I'm telling you this, don't tell anybody.
It's between you and me
and nobody else.
And the audience at home.
Right. Many times we go over the retainer of 10 hours of work, and we are not charging for all those hours, but don't tell anybody.
Right. My lips are sealed.
Okay. So then we are, the person, Mary, will be educated when to call me. Don't call me, what's going on with my case? Because I will tell her, once we present the summons, we give the summons to the sheriff, there will be 30 days for the sheriff to serve. So I give them an example. And so I go through the whole process. And then once your husband gets served, then he has 30 days to respond. So don't call me. If I have any news, I will call you and I will contact you. But don't call me, just wait the 60 days.
Right.
And I put that in when I send them the notice that we have filed the petition, for example.
Very important to have realistic expectations about how quickly things are going to get done in this system.
Yeah, and sometimes many people will come and say, yes, I want to get the divorce. This is another thing, that initial interview is so important, and experience will let you know. The one who comes for an initial interview to get a divorce because they want to get it over with, that's the wrong attitude to have. Well, not the wrong, the mistaken, that because you are filing for divorce, you're going to get it over with.
Yeah.
Especially if there are children.
Yeah, you have to adjust your expectations about the time.
Temper them, yes. You have to temper their expectations. And then I will keep Mary informed of the progress of the case. Well, your husband was served. Well, in our example, she was served, but let's change it. So, your husband was served on such and such a date. He has until such and such a date to respond. If he doesn't, then we can ask the court to default him. And if we default him, I explain to them what a default is, and then the fact that she will get whatever she asked in the petition awarded by the court.
Right.
Okay.
So a default judgment is a judgment that would be entered in the absence of an appearance by the opposing party.
Right. The husband didn't say, hey, I want to participate in this dissolution proceeding.
Right.
He didn't do anything.
So that means that, and nobody should expect this, but that means that whatever you asked for in your petition for dissolution, you're going to be awarded by default because nobody attempted to respond to the petition or argue for something different.
However, you have to explain to Mary that even though we have defaulted her husband, and even though we're going to go and try to get the default, the authorization from the court in order to do the prove-up, the final prove-up, you have to give the husband notice that the judgment, or you are organizing or setting up or scheduling the final entry of the divorce. And at that time, sometimes the husband realizes, oh, whoa, this is, I want to have the custody of the children, for example.
Right.
And so he will appear in court. You have to give him notice. And now by Zoom, it's a lot easier. He will appear in court and he will say, I have just, I want to participate in this. The judge, believe me, will not allow a judgment for dissolution of marriage to be entered without, by default, if the party wants to participate. So
Right.
the judge will say, how much time do you need to appear in court?
And then the process almost starts again.
Exactly,
Right.
all over
And
again.
you may have a trial. And if
Yes.
Right.
Fortunately, I haven't had any.
Doesn't happen that frequently.
No, because with our constituency, the poor and the working poor, they don't have the money to go ahead and do discovery, interrogatories, and depositions, etc., which are all needed for the trial. Secondly, they don't have the assets
Right.
to be fighting over.
Right. So there's no real
An
incentive.
incentive to go to trial, and then after the initial interview, we are telling them our goal is to settle this.
Right.
To settle it.
To come to an agreement.
To come to an agreement.
So we have we're starting to run out of time, and I did not want to miss an opportunity to ask about the work you do as an attorney for the children. Although we don't have a great deal of time, I thought maybe you could talk about that just briefly.
Just briefly, okay. Different from the family law practice that I have, I don't have clients coming over. The court, I am on the list, on the roster of attorneys who are qualified to represent children in contested, what used to be called custody. And so the court appoints me. I don't have clients coming. They don't come to the clinic.
Right, right. So, so this would be a case where you have, as you said, a contested divorce, and the court
with
children involved, and the court feels a need to figure out what is in the children's best interests in terms of how custody should be arranged, shared, awarded, etc. And they need an objective party to figure that out, who is not in the interest of the mother or the father. And
exactly.
so the court appoints the attorney.
Right, right.
And you are on the list of attorneys who would be appointed in that situation.
Right.
So what do you do in those cases when you are appointed?
Do you have
30 seconds are left. No.
No, well, the most important thing that you can do as a child's rep or as a GAL, because it has different roles, is you do an investigation.
Right.
And you talk to other parties if necessary. You talk to mom, you talk to dad, you talk to your clients.
The child, right.
Depending on the age, of course.
Right.
If they're babies, forget it. And then if you feel the need, you will talk to additional parties like the grandmother or the babysitter or the school. You will do the investigation. Then if you are a GAL, you will write a report to the court. If you are a child's rep, you can go ahead and participate. If the matter goes to trial, you can participate in the trial, and you can bring your own cases, your own evidence, etc., etc.
Yeah. That, I think, is it's something I didn't want to overlook because it's a unique skill set and a really important service that we provide.
Right.
So
unfortunately, we do not have anybody else at the clinic that can do that.
No.
So it's important that we try to get somebody to become also a member of the roster of attorneys.
Good luck to us on that. Good luck to us finding somebody who can do what you do. So, but fortunately, we don't have to do that just yet. Marta C. Bukata, MCB, I want to thank you for joining us and thank you for everything you have done for the clinic over decades. We are very appreciative.
I'm delighted to have done this.
Thank you.
Okay.
And thank you for tuning in to Legal Aid Explained. We will see you next time.